So let's now walk through some of the specific issues and how this might impact your benefit plans. Starting with the welfare plan issues, where I think the most vast changes are occurring. Pre-Windsor, plan sponsors essentially had the ability to define who was eligible for coverage. They could choose to cover spouses or not cover spouses for that matter. And if they chose to cover spouses, they could choose to define or elaborate on how they define spouses now, or how they define who was eligible for the plan. From a federal tax perspective, they were still bound in their definition of spouse from the perspective of whether you could treat that individual's insurance coverage as pre-tax or post-tax. But you could choose to only cover valid federal spouses, or you could choose to cover spouses that are recognized under state law, or spouses that are civil union partners, domestic partners, etc. Pre-Windsor landscape, you could pretty much cover whoever you wanted. State insurance was the one exception here, obviously, because state insurance laws are not preempted by ERISA. So to the extent that you sponsor a fully insured plan, a state might mandate who you cover under your plan. For instance, Illinois passed the civil union law in 2011, and they mandated that all fully insured plans cover civil union partners to the same extent that they cover spouses, obviously with the exception of favorable federal tax treatment. And obviously, plan sponsors could choose not to cover same-sex spouses or civil union partners, et cetera, to the extent that they were in a fully insured plan, were not prohibited in any manner. So you saw many plans doing that. Now, there was a shift over time, and it varied across the political spectrum and geographic region, et cetera. But many employers started realizing that from a competitive advantage, they needed to recognize same-sex marriages or the equivalent. The other thing you started seeing very progressive organizations do was provide some sort of tax equalization treatment for same-sex coverage. So because federal tax law wasn't recognizing or giving people the tax benefit for same-sex marriages, a lot of organizations said, well, we're going to step up and do fill in the gap where the federal government doesn't do so. And so while an individual who was covering their domestic partner previously would have had to pay tax on that individual's coverage and have that amount treated as imputed income, essentially like that individual received cash even though they didn't get any cash, the organization would step in and gross them up with additional wages to offset the cost of those taxes that were imposed on them, so that essentially everybody in the organization was treated the same from a tax and benefit standpoint. That was pre-Windsor, but again, nothing across the board, no federal recognition of same-sex spouses. Post-Windsor, the landscape obviously changed. Plan sponsors are still free to define who they recognize from a plan coverage standpoint. Choose not to recognize spouses. And in fact, technically plan sponsors can still choose to limit coverage to opposite-sex spouses. We're not mandated by state law. Obviously, you could say we're only covering opposite-sex spouses. Now, the problem there is that there's some risk that organization could face a Title VII discrimination suit. And this isn't my area, but as it's been explained to me, the way the argument goes is that Title VII prohibits discrimination based on gender, and federal law recognizes spouses as spouses regardless of which gender they are, if recognized under state law, and it is gender discrimination to cover spouses of the opposite gender but not spouses of the same gender. That's how the argument flows. Now, there hasn't been a lot of case law developed around this argument post-Windsor when the legal landscape changed a little bit, but you can rest assured that it will bubble up. So the tax treatment was obviously the big change under Windsor. And obviously prior to Windsor, under code sections 105 and 106, employer contributions for health coverage are not taxable, and also employee payments, premium payments for health coverage are available on a pre-tax basis. DOMA, though, obviously said same-sex spouses are not spouses, so to the extent you were covering a same-sex individual under your plan, the likelihood is that you could not pay for that individual's coverage on a pre-tax basis, and the employer's contribution for that coverage, be it through a self-funded plan, the portion that they're essentially subsidizing, or through a fully insured plan where you're actually paying the amount to the insurance company, would be treated as taxable to the employee. And those could be significant sums of money because, COBRA rates for coverage can run easily in excess of $10,000, and that's $10,000 additional dollars in taxable income that employee has, even though they're not actually receiving that money, and they're paying taxes on those amounts. So obviously the landscape changed, and now, especially following the state of celebration rule, or state of ceremony rule, I guess I should say, any individual who's validly married under any state law or any foreign jurisdiction law can be treated as married from a federal tax perspective for employee benefit plan purposes. So if you're covering somebody and they can provide you with a marriage certificate, while you're not required to get a marriage certificate from them, if they can prove that they're married or represent that they're married, you're allowed to provide coverage to that individual and that individual's spouse on a pre-tax basis. So significant savings there for employees, big change.